सुप्रीम कोर्ट के आदेश पर चुनाव आयोग ने हाल ही में अपनी वेबसाइट पर इलेक्टोरल बॉन्ड की डिटेल्स अपलोड कर दी। हालांकि इसमें बॉन्ड नंबर नहीं है। सुप्रीम कोर्ट में सोमवार 18 मार्च को इलेक्टोरल बॉन्ड मामले पर सुनवाई हुई। अदालत की संविधान पीठ ने इलेक्टोरल बॉन्ड के यूनिक नंबर का खुलासा करने को लेकर सुनवाई करते हुए स्टेट बैंक ऑफ इंडिया (SBI) को फटकार लगाई है। चीफ जस्टिस DY चंद्रचूड़ ने कहा कि SBI को हर जरूरी जानकारी देनी होगी। इस पर SBI ने कहा कि उसे बदनाम किया जा रहा है। दरअसल सुप्रीम कोर्ट में पिछली बार जब इलेक्टोरल बॉन्ड को लेकर सुनवाई हुई थी तो अदालत ने बॉन्ड के यूनिक नंबर का खुलासा नहीं करने को लेकर SBI से सवाल किया था। अदालत ने कहा था कि SBI को यूनिक नंबर का खुलासा करना चाहिए क्योंकि वह ऐसा करने के लिए बाध्य है। यूनिक नंबर के जरिए ये पता चल सकता है कि किस राजनीतिक दल को चंदा दिया गया और चंदा देने वाला शख्स और कंपनी कौन थी। चीफ जस्टिस DY चंद्रचूड़, जस्टिस संजीव खन्ना, BR गवई, JB पारदीवाला और मनोज मिश्रा की संवैधानिक पीठ ने इलेक्टोरल बॉन्ड के यूनिक नंबर को लेकर सुनवाई की। सुनवाई के दौरान चीफ जस्टिस DY चंद्रचूड़ ने SBI की तरफ से पेश हुए वकील हरीश साल्वे से कहा कि हमने पूरा ब्यौरा देने को कहा था, लेकिन SBI ने चुनिंदा जानकारी दी है, वह ऐसा नहीं कर सकती है। इस पर साल्वे ने कहा कि हम सारी जानकारी देने को तैयार हैं। चीफ जस्टिस चंद्रचूड़ ने कहा कि आप हर बात के लिए हमारे आदेश का इंतजार नहीं कर सकते कि कोर्ट जो कहेगा वही हम करेंगे। आपको आदेश समझना चाहिए। इस पर हरीश साल्वे ने कहा कि SBI के बारे में गलत छवि बनाई जा रही है। हम साफ करना चाहते हैं कि आदेश में क्या लिखा था। हमने समझा कि बॉन्ड की तारीख, बॉन्ड खरीदने वाले का नाम, राशि और कैश करवाने वाले का ब्यौरा देने के लिए कहा गया है। सुनवाई के दौरान साल्वे ने कहा कि चूंकि राजनीतिक पार्टियों को चुनाव आयोग को बताना था कि उन्हें किसने चंदा कितना दिया है और यह जानकारी सील लिफाफे में कोर्ट को भी दी गई थी, इसीलिए यह जानकारी सामने आ ही जानी थी। उन्होंने कहा कि अगर बॉन्ड नंबर देना है तो हम दे ही देंगे, इसमें हमें कोई समस्या नहीं है। अब आपको बताते हैं कि इस सुनवाई के दौरान आखिर क्या क्या हुआ। CJI ने हरीश साल्वे से सवाल किया कि हमें बताइए कि आंकड़े आपके पास किस रूप में थे। साल्वे ने जवाब देते हुए कहा कि पहले गोपनीयता की शर्त थी, इसीलिए अलग अलग रखा था। इस पर चीफ जस्टिस ने कहा कि पहले आपने 2 अलग जगह पर आंकड़े बताए थे, अब ऐसा लग रहा है कि 3 जगह पर आंकड़े थे, बॉन्ड नंबर अलग जगह पर था। साल्वे ने जवाब देते हुए कहा कि नहीं, 2 ही जगह पर था। चीफ जस्टिस ने सवाल किया तो फिर अल्फा न्यूमेरिक यूनिक नंबर का इस्तेमाल क्या था? क्या कैश करने वाला ब्रांच नंबर मिलाकर भुगतान नहीं करता था? साल्वे ने बताया कि नहीं, यह KYC के आधार पर भी कैश हो जाता था। इस पर चीफ जस्टिस चंद्रचूड़ ने कहा कि ठीक है, हम अब आदेश दे देते हैं कि SBI बॉन्ड नंबर भी बताए और अपने पास और भी किसी तरह की जानकारी न रखे, सब बताया जाए। साल्वे ने कहा कि बिल्कुल, लेकिन मीडिया में और दूसरी जगहों पर हमें गलत बदनाम किया जा रहा है। हमें कोई जानकारी छुपाने में दिलचस्पी नहीं है, हम सब कुछ उपलब्ध करवा देंगे।
For the State Bank.
Yes, Mr. Salve, in
Yes.
our order which we in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So, let SBI not be selective in the disclosure of details. We intend to clarify that it shall disclose all details, including the bond numbers and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court. SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
How we understood
SBI requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I am duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, State Bank of India has the best legal advice open to it.
Just one more thing.
I have 2 minutes, Lord, if your Lordship permits.
at the outset, my lord, on behalf of the central government, I completely disassociate myself with what Dr. Agrawala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my lord, on behalf of the central government. Now, my lord, I have something to share, and I have been watching this very painfully, my lord, outside the court. My lord, your lordships sit in kind of a silos. The lordships are, my lord, in an ivory tower, not, my lord, in a negative sense of the term. But what we know here, my lord, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country. But what has happened? My lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy, and we could not persuade your lordships. Lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SBI before your lordships on 11th of this month, my lord, and your lordships also, my lord, that's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, Lord, a non-level playing field. My lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. Lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, Lord, any kind of posts are being made. I know, my lord, your lordships cannot control that. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rodgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of Para 221.
That's
as judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not, my lord, for a second.
Our court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter this started in a very systemic.
Already. Order.
Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we will not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
One will allow us.
Mr. Rodgi, no, Mr. Rodgi. I told you the reason for it. We are now at a stage when the judgment.
I am not on my application. Not that it become influential. I am now only saying.
No, Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party assistance.
The lordship didn't get a proper assistance.
So just one thing. The grievance of those who will now be deemed that who have A party, who have given to B party, that will be
Lord, one more clarification.
What we did, we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition. Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court. And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization of B?
Answer is yes. Answer is
The answer is yes.
My Lord, only one line, my Lord. Only one line, my Lord. Mr. Bhushan may, my Lord, now hold his order.
Pursuant to your...
He has done, my Lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning, my Lord. That my disassociating from Mr. Agarwal doesn't mean that I am...
Mr. Solicitor, irrespective of
but maybe treated as well.
We must just tell you that we respect this very responsible approach which the Solicitor General has adopted because, clients apart, who you are representing apart.
It is really painful, my Lord, when the people before the court start, my Lord, a media campaign to embarrass the judges.
Thank you for saying that you don't associate with the mentioning. Thank you for saying that you don't associate.
Because there is no level playing field. I can't hold a press conference.
only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are...
Last order, the election commission has put out the sealed covers, but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into all that, Mr. That's not our remit at all.
No, I know.
What has happened after the judgment is not something we are concerned with
Not after
at all.
the judgment. What I am saying,
Now,
what I am saying is this, that since the order of the...
Very recently I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. It is the property of the nation. And,
No, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the election commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not addressing your lordships, he is addressing somewhere else. Kindly hear him for some time. So that it comes, my Lord, in the newspaper tomorrow, that Mr. Prashant Bhushan vehemently said this. That's the purpose.
Unfortunately, public interest litigation have now become publicity interest litigation.
It is publicity interest litigation. It is, my Lord, there are some hidden agendas. There is no doubt, my Lord, and I am not, my Lord, apologetic in saying.
I am astonished.
And Lord, that is the matter of greatest concern, because judgments given, my Lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships in your Lordship's Majesty would not know, my Lord, what are the hidden agendas behind.
Just dictate a short order. I think, we are unnecessarily expanding upon the remit.
Because the major political parties have not disclosed the donor.
Just give us 2 minutes to
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
they have filed an application.
Mr. Ansar, just one moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes.
Right? In our interim order, we said that the disclosure shall be made with effect from the date of the interim order,
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also should explain why we took that date. We said after that date, of course, the Constitution Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodki. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
So the only reason why I'm saying that...
modify that date.
No, the only reason, because your Lordship asked the political parties to give donor details to the Election Commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore I am saying that because this is leading to a situation, though your Lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties...
Bhushan, we have understood that argument, but what we are directing, once the numbers are given, it will sort out a lot of problems. A lot of your issues will
But for that period of 2018 till...
Oh, that will...
we are not sitting in a review.
We have taken a conscious decision.
We are faced with a situation where the...
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
No.
And
in the light of the disclosure which has come to light of the political parties, that's why I'm saying.
And it was not a
if the political parties had disclosed the donor details, this would not be required.
Draw the line somewhere, we had to hold the balance. We've held the balance ultimately.
As your Lordship pleases, but I just...
Can I just add one sentence? Lordship said all the details. Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. Just, I'm not saying just. When a Lordship said all details, not in my respectful submission, it will be.
Mr. Sarve,
No, Lord, Lordship, just permit me a minute.
Sarve has fairly stated that he will all the details.
No,
Why?
Yes, yes, my lord.
No, my lord, if I can just show.
And date are all already
What your
disclosed.
Lordship would say, my lord. I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party. And sixth column would be the amount. My lord, this will cover all the details, not in my respectful submission.
My lord, this is now asking us to sit down and collate one.
This is a submission made to the court. Just like Mr. Salve made a submission to the court. I'm making.
Yeah, we need.
Very well. I'm making a submission to the court. Mr. Salve asking us to do whatever. Look,
Please permit my lord the Chief Justice to dictate the order now at least.
Secondly, my lord, the Lordship said, Lordship has seen that IA, my lord. I filed that IA. For a pre-period, if a Lordship have taken a conscious decision on that aspect of the matter, my lord, Lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a Lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only because we said, my lord, it should be, my lord. Otherwise, logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter, very well, I'll leave it at that.
And there is a specific direction with effect from 12th April.
Then your Lordship said, I will not press the application.
So, Bhushan, there will be no end to it.
IA, what is the IA number, Mr. Ansariya? Just 1 second, Mr. Bhushan. IA number which you are not pressing is IA number?
Diary number 12580-2024. Which is MA number. MA diary number.
So that you are not pressing.
Yes, madam.
Just
Just
one,
say MA
by way
diary
of
number
information on
12580-2024. Mr. Vijay Hansariya, Learned Senior Counsel, appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of whatever proceedings have gone to the court, in view of the proceedings before
Whatever in view of whatever.
Lord, if a lot, you can say that.
Otherwise, in view of what? In view, we'll say, in view of the specific directions contained in paragraph 200, in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
just one fact by way of information.
Enough of assistance by this public-spirited person, my lord. Your Lordship doesn't need any further assistance.
The details of the number of bonds shown by the in the data.
He is gathering the details for a future PIL, my lord, so that remains in. He remains relevant.
Now, please permit my lord the Chief Justice to dictate the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores and the amount redeemed is 12,769 crores, that is 550 crores more than what were purchased. Now the explanation for this could be because the data is from 12th April. At that time the bond purchase was going on. On 12th April 2019 it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019 but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, Malad, these figures are not authentic. I have given the authentic
18,000 versus
roughly
Sponsored NGOs are, my lord, fudging the figures and bringing their own. My lord, your lordships are aware, there is a beautiful my lord, quotation by Einstein that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that 18,000.
This is what happens when
now leave it at that.
Those numbers are not right. Since because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.
अलग order pass कर देंगे. इसमें MA में ऐसा लिख लीजिए. This court issued operative directions. Of these directions, in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019 into inverted commas till date to the ECI into inverted commas complete. Such details, the court has indicated into inverted commas shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased into inverted commas complete. In the second part of the operative direction, in subpara C, SBI was required to submit into inverted commas the details of political parties which have received contributions to electoral bonds into inverted commas complete since the interim order dated 12 April 2019 till date to ECI. Full stop. SBI was required to disclose details of each underline each electoral bond encashed by political parties and to include inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and the plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression to invert commas include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. But stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of and the serial number, if any, of the bonds which were purchased and redeemed. Full stop. The application, this was on your application, I think you had moved this, no? The application was by the applicant. Oh yeah, we had this. Therefore, Mr. Harishan Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
Could we have one more day on Thursday?
Stating, yes, certainly. 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
This will be given to the Election Commission.
In terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details.
इस प्रकार से आज 18 मार्च को हुई सुप्रीम कोर्ट में सुनवाई के दौरान यह सब हुआ। AP 100 TV लाइव ब्यूरो रिपोर्ट।